My lobbying colleague, Anthony Sampson, and I have written a few uh, regulatory process type articles over the years. And something that we've heard from legislators, lobbyists, and others who would like to see California's executive branch administrative agencies and departments considered getting rid of expired or outdated regulations, or perhaps amending existing ones that have become problematic. Um, there's actually a process for doing so. Many regulations have been on the books perhaps for too long. Sometimes even the law that originally authorized them have expired or been repealed. But California, in the 28 titles, have more than 60,000 regulations on the books. Some regulations have become unnecessary or too burdensome to the regulated community. Now, believe it or not, California law actually enables any person, whether you're a lawmaker or a member of the general public or obviously the regulated community, to seek the repeal or amendment of an existing state regulation. And in reviewing petitions to state agencies, the most common petition is one to amend an existing regulation. Now, if you're interested in the fine print, that petition process is found in the APA, the Administrative Procedure Act, which is contained in California's Government Code, and specifically look at sections 11340.6 and 11340.7. And basically, the formal petition process consists of a letter requesting an amendment or a repeal of an existing regulation. And you submit that formal letter, that petition, to the rulemaking body that adopted and administers that particular regulation. Now, the written petition has to identify the nature of the regulatory change you're proposing, or the regulation to be repealed, and of course, the reason for requesting the petition, and a citation of the agency's rulemaking authority to either change or repeal that regulation. Now, although the petition procedure is formal, it's rather simple in its application. And the process is very similar to the federal APA that's found at 5 U.S. Code Section 553, Subdivision E. Now, under state law, the agency has to notify the party who filed that written petition, and the state agency has to respond with any denial within 30 calendar days. Moreover, that agency's denial has to be in writing and include an explanation of why the agency is denying your petition. Now, if there's no denial, then the state agency has to conduct a public hearing on the proposed regulatory change. In addition, the state agency notifies our OAL, the Office of Administrative Law, of that agency's decision, and they publish it in the California Regulatory Notice Register so that the public is aware of the agency's proposed action. Now, OAL will utilize its 6 statutory standards to determine whether the regulatory changes meet the requirements of necessity, authority, clarity, consistency, reference, and non-duplication. So anyone who files a written petition should certainly consider these legal standards when you're petitioning for a change in an existing regulation. And successfully written petitions usually state clearly and concisely the substance or the nature of either the proposed regulation or the proposed repeal that's being requested. and a good explanation, a thorough explanation or reasons for making that request. If the petitioner has supporting documentation, a technical study or something like that, that should certainly be submitted, or any other legal basis for amending or repealing the existing regulation. As you can probably imagine, the more thorough and persuasive one's written petition, the more likely it will to be successful in the end. Now, the petition is an important option for interested parties to pursue, and it's particularly so in cases where regulations have, at least those, the view of those who file these petitions, that the regulations have become unduly burdensome or have created unintended consequences or been misinterpreted, or something's inconsistent since the time that the regulation was originally adopted by that agency or department. Now, some have advocated for an approach of no new regulations, without repealing an existing one, for example, a one-for-one. But really, the obligation of improving and streamlining regulatory burdens is not to be placed exclusively on the rulemaking agency, but also on regulated entities, regulated individuals, elected officials, members of the general public, some of whom may be in a much better position to either propose amendments or repeal some amendments that no longer serve their purpose. So if a member of the public or a colleague can identify a California regulation that needs to be changed or even repealed, they don't have to just rely upon the regulatory agency to take some sort of initiative. Instead, that there's an existing process for those people to file a written petition and get that agency to amend or repeal its regulation.